Hi, Amanda. Oh, I can't hear you. Can you hear me?
Oh, yeah, no, so I had myself muted.
Okay. How you doing?
I'm doing fairly well. How about yourself?
I'm good. I'm trying to make sure I have the right address to go to the funeral.
Okay, what time does that start
It's at
today?
11.
It's 11, okay. And you said that the Fosters are bringing Levi to
Yes,
the
ma'am.
funeral.
I just got off the phone with her to ensure. Yeah, she is.
Well, good.
And as soon as I get with mom and dad about visitation, I'll let you know. Because I
Okay,
just didn't
perfect.
want to pile up everything on them because we were trying to do the payment and what was needing, what was left over that the state didn't pay for. It was a mess.
Oh gosh.
Yeah. So I
Yeah,
didn't
I
want
could
to
imagine.
add something else.
Yeah, no, that makes sense. And I think from what I understand, I don't think they'll have a problem with just doing virtual in the meantime. But who knows? They might change their thought on that, and that's
Okay.
perfectly
Yeah, that's
perfectly
true.
fine.
Yeah. Hello, Robin.
Hey there. Just realized it's different. I have to have my laptop and my big top on. Like, why am I not moving? So, okay. All right. I'm going to just put mine on mute for the moment.
Well, good morning, everyone.
Good morning, Judge.
Good morning, Judge.
Good morning.
All right, so it's 9:30. So here's a question. Does anybody want a record for this one? The court reporter is not in the courtroom.
We don't need a record, Judge.
No, Your
All right. Okay. So the court will call cause number 323-108-675-18. This is filed in the interest of Amari DeMontre Boone and Levi Lee Boone. We're here with the department having previously filed a motion to modify possessory conservatorship That's a Levi Boone only. This was filed a couple weeks ago. There's currently temporary orders removing Levi from what was the possessory conservator back into the care of the permanent managing conservator. The court will take notice that on November 13th of 2019, this court signed an agreed final order on the SAPSR that named the department as the permanent managing conservator. And in January of 2020, this court signed an agreed order appointing Ms. Foley as the possessory conservator. Subsequently, there's been, I guess, a tragedy involving Amari. This is the one, correct?
Yes, Judge.
Okay. So the one sibling is now deceased, and now we're dealing with Levi. And so we have this emergency hearing. The court also took notice of a report filed by that item on April 23rd, 2020. Ms. Rourke, that was yours. And so that is in the file. And previously submitted prior to this hearing is an agreed order modifying possessory conservator. Has everyone received a copy of this?
Yes, Judge.
Yes, Judge. So everyone except Mr. Foley. I had drafted the order. It's been signed by the parents. We've tried to reach Mr. Foley just to get him to sign it, and he's not responding to the department. I guess that's not unexpected. So Gladys Demas is the case worker, the ongoing case worker. She's left him voicemails. We did send him notice of this hearing and have not heard from him. So, so to the extent it says agreed, I had drafted it as agreed because I thought Mr. Foley would sign off, but we have not been able to reach him.
I understand. All right, then, Ms. Demmer, do you want to go ahead and proceed and present, sufficient evidence?
Well, Judge, I would ask the court to take judicial notice of the evidence presented in our motion, and submit that that affidavit that's attached. Our motion was filed on April 13th, 2020. It was accompanied by the affidavit of the caseworker at the time, Sheila Roberson, and I'd ask that the court take judicial notice of that motion and that affidavit and grant the requested relief based on that. But if the court's not inclined to do that, then I could call Gladys Demas as my witness. She's the ongoing caseworker now, Judge.
All right, so I guess the only person, everyone else has signed off on this aside from Mr. Foley.
Yes, Judge.
All right. Okay, and so the movement being the department is requesting the relief submitted in this proposed order?
Yes, Judge.
Okay. All right, so the court will take notice of the documents previously filed with this court of all the information in there, and we'll consider that all the parties, including Ms. Ariana George, Mr. Rodney Boone, the advisor for the child, Ms. Rourke, as well as the department has agreed to this order, Mr. Foley not being present to agree, but also not being present to contravene or to disagree with evidence before the court. I've made a couple changes to this order, just so you know.
Okay.
I did put, because of the language for appearances from Ms. Rourke, I did put that she appeared, instead of in person, I put via Zoom.
Okay.
That's sufficient. And then on the second page, under managing conservatorship, I put, it is ordered that and I entered the word previous appointment of the department. I just didn't want to seem like we were modifying the permanent management.
Okay. Okay.
So,
okay.
Since that wasn't pled, I just want to make sure that
Yes.
it didn't look bad. And otherwise, I've left everything else the same. I'm dating this April 24th of 2020. And I've signed this order. I'll give this to Stephanie and she can distribute copies of the signed order to the parties requesting it. And for the docket entry, I just put, we had a hearing on the motion to modify possessory conservatorship. Agreed order submitted, signed. Parties all agreed as submitted, except for Mr. Foley, who did not appear. Okay. Anything else we take care of?
I don't think so, Judge.
Right.
We have an order for an expedited home study that was signed back on a week or so ago, and that is in the process and it's being done. So
okay, good. Just for housekeeping purposes, can I see where Mr. Foley received notice of this hearing?
Yes, Judge. We sent notice April 20th, 2020. That should be in the court's file. It was sent to the coordinator, Stephanie Hester. And we advised that the hearing would be heard by Zoom and that the party should contact the caseworker or the court to determine the best way to participate in that hearing. And it was sent to Mr. Foley by certified mail. And again, Ms. Demas has left him several messages, most recently yesterday. Is that right, Gladys?
Yes.
Yeah.
So Ms. Demmer, you're representing that the temporary ex parte order with the setting date for April 20th. That's the one that y'all provided a copy to Mr. Foley?
Yes, we sent a letter dated April 20th advising him of today's April 24th hearing. So 3 days, more than 3 days notice.
Okay. Okay. Well, thank you very much. Is there anything else we can take care of?
No, Judge.
Okay, thank you. That'll conclude this hearing. Y'all be safe out there.
Thank you. Good to
Thank
see you, Judge. Bye.
Bye-bye. Bye-bye, y'all.
Yeah, there's a video, but he has it all muted.
Hi, how are you? Good, good. I'm doing the best I can.
So, Mom, you'll have a seat up there. We should start in just a couple of minutes, okay?
They can hear me? Not yet, because we haven't started the meeting. All right.
Oh, I don't think it matters. All right, so this is the detention docket for the 323rd District Court. We'll go ahead and start. So Mr. Brito, are you there?
Yes, sir.
Okay, so this is a detention hearing. The law says when a child is brought to our detention facility, within 2 days, you have to see a judge to make a decision to keep you in custody or to release you. Now, you've previously been here and we've detained you last time. So every 10 days, you have to see a judge to make sure, for the court to make a decision whether or not to keep you here or to release you. We're here today because your attorney, Mr. Mooring, requested this detention hearing. Mr. Mooring, are you present? All right, well, Mr. Brito, if you go out and wait, and then if Mr. Mooring shows up, we can. If not, then we'll see you at your 10-day hearing, but I can't go forward without your attorney. Do you understand?
Mm-hmm.
All right, thank you, sir. All right, Ethan Gaither. Is Ms. Jacobson present?
Judge, he's my client.
Oh, Mr. Shaw? Okay.
Yes.
Oh, I'm sorry. I have some of this paperwork mixed up.
Yeah, he's out of custody referral.
Mr. Shaw?
Yes.
I'm kind of stating the obvious, but just so you know, he was picked up at home last night around 6 p.m.
Oh, okay. All right. Yeah, well, I saw the uniform on him. I guess that changed.
Yes, sir.
All right. So, all right, Mr. Gaither. All right, this is a detention hearing. The law says when a child is brought to a detention facility, you have to see a judge within the first 2 business days and have to make the decision whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 business days to make that same decision. You have the right to remain silent. However, if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you do have a right to an attorney. If you or your family cannot afford an attorney, I will provide one for you. So we can go forward. So, Mr. Gaither, you're 16 years old. You were previously referred in March of last year for aggravated assault with a deadly weapon, for which you had a supervisory caution. And see, you gave a drug test back in February, you're positive for marijuana. And then yesterday when you're brought in, we give you a drug test and you're negative for all substances. So that's good. All right, so let's see. Yesterday, Judge Porter issued a warrant for you. Arlington Police went and picked you up. Apparently, since you were released on March 23rd, you've been sneaking out of your house, getting high, as evidenced by a failed UA test that your parents administered to you. Parents called us, told us that they were concerned about your behavior, both in general as well as with COVID-19 happening. Your parents are concerned because you actually are suffering from asthma, which makes you at a higher risk group. You have pending cases for unauthorized use of a motor vehicle and evading arrest with a motor vehicle. That was from February. Let's see. According to the police, a student's car was stolen from the parking lot at Bowie High School. She lost her keys. So saw her car later, police started chasing, and you ran in her car until the car wrecked out. And you were noted as a driver. They saw you when you ran. Police set up a perimeter and arrested you. So you got to level 1 outstanding. Judge Porter released you, and then evidently when you went home, you thought you were going to do your own thing. So I guess you were level 1 outstanding here on detention facility, but when you went home, you're a level 3 unacceptable. Mom, is that about right?
That's about right.
Okay, so that being said, the reason why it's important for us to get kids to level 1 outstanding is to prove to me and prove to you, Mom, that he can do it. He can't say I can't do it. We know he can do it.
Right.
So now we know it's not a disorder or a problem, it's a choice. Right. He's making poor choices. Mr. Gaither, good decisions come from experience. Experience comes from bad decisions. So going forward, Mom, the fact that you're very communicative with us, the fact that you kept us informed and you're expressing your concern for your son gives me a lot of faith and confidence in you. I want to work with you. Okay? I'm kind of like that top level, you're the boots on the ground. Okay. The county can't supervise Ethan for the rest of his life. the rest of his childhood, we're relying on the parents.
Right.
So I want your opinion. What do you think is appropriate for Ethan? What can we do to make sure that he actually follows the rules and behaves?
I want Ethan home because I want to be able to keep an eye on him to know that he's okay as his parent. So I would like him home. I'm thinking maybe electric monitoring to give him that little boost to walk the line a little bit more. Schooling's important to us. Testing clean is important to us, and staying inside while all of this is, is happening is important to us.
Sure. All right. So, let's see.
Good kid, like you said, good kid, just making bad decisions.
All right. Well, hopefully that's all we need. All right. So, Mr. Lewis, how long was he in detention last time before he got to level 1.0 and released?
Approximately 3 weeks, Your Honor. His 10-day plus another week to achieve that level.
So he took 3 weeks to get to level 1 outstanding.
Let me look at his detention record from his last stay, if I may. He was in detention from February 29th to March 23rd. He reached level 1 outstanding, it looks like on March the 3rd. He had no major infractions or confinements or major disciplinary issues. He had one minor non-compliance for refusal to participate, but other than that, he did well.
Why did it take so long to get out?
I believe the stricture that the judge put on him was he had to hold it for a certain number of days. If I remember that correctly.
Okay.
Judge, I can jump in here. It's the parents didn't want him to come home.
Right. I think my husband did express at the hearing before they released him, so I guess a week prior, that he would like him to be continued.
Yes, I'm on it now. Apparently I got the wrong number and URL, but I'm on it now.
Mr. Mooring?
Yes, I'm here.
Your mic is on. Thank you. All right. So, Mom, you were saying?
I think the week before they released him, my husband had appeared in court and asked that they continue to detain him as well. I don't recall what his reasoning was, but I think he did ask for them to keep.
All right. So this is where I'm going. Typically, whenever a child is in and we set the goals, every time we raise the bar. Okay. So normally what I do is last time it was hold it for 7 days. This time I'd probably say hold it for 2 weeks. All right. And we just keep on going up. Now, that being said, Mom, if it seems like what was kind of holding on detention is you and Dad felt like you were waiting for an appropriate time. I think y'all are very engaged. I think y'all are what appears to me very good parents. And so I'm going to defer to you on this one, right? Do you think this experience of being picked up yesterday is enough for Ethan to have learned his lesson? Or do you think we just need to go forward with what I normally do?
That's a tough one. I don't know. You know, the whole point in us calling you is that I wanted him to take it seriously.
Sure.
I think he thought with COVID-19 that it would be easy to slide under the radar and nobody was really going to check up on him. So I'm very pleased that you guys took action so quickly. So thank you for that. I honestly don't know if Ethan will learn a lesson from this or if he won't. I'm not sure.
Sure.
Yeah.
All right. So this is what I want to do, because part of my concern is, one thing is the theft. One thing is the evading arrest of the motor vehicle and crashing out somebody's car. It shows a lack of respect for authority.
Absolutely.
I think we're seeing that right now. I think him having problems getting to level 1.0 is indicative. So we'll just go ahead and do what I normally do, Ethan. All right. So I'm going to detain you, and you're going to stay here. You get to level 1.0, and then you hold it for 10 days, at which point then we'll go ahead and release your electronic monitor. But if you can't get to level 1.0, then you'll just stay here. And then when you get out on electronic monitor, if you can't be level 1.0 when you're at home, then we'll just come back here and you can prove yourself a little bit longer the next time, all right? And this is just the way it's going to work. Eventually, you're going to turn 17, and when you commit offenses, you'll just go to the adult jail, at which point, if you don't have the money to bond yourself out, then you'll just sit in adult jail forever until your case is done. At least with juvenile cases, we'll check up on you and find reasons to release you. There is no amount of money that can get you out right now. It's doing what we feel is best for you. But as an adult, it does require money, and that's what you have to understand is the difference. Is right now, the the fact that you're a juvenile, you don't have anything, doesn't affect you getting in or out. But you could have all the money in the world and it wouldn't affect you getting in and out either. Okay, I hope you understand the difference because you're turning 17 this year. Okay, do you have any questions for me, Mr. Gaither?
No, thank you so much.
All right, thank you, Mom.
So they're detaining him for a minimum of 10?
That's right.
No, there was not one on there.
Minimum of 10.
All right, so we'll go to, oh, he was retained. Mr. Shaw was retained. Enya Mason.
One up here, and then here's the one talking.
Yeah.
And then here would be
okay.
in this
Got it.
area right back here. Thank you.
All right, and then we have Mr. Hall I saw previously. All right, so Ms. Mason, this is a detention hearing. The purpose of the hearing is that the law says when a child is brought to our detention facility, you have to see a judge within 2 days. I have to make the decision whether to keep you in custody or to release you. By keeping you in custody, the law says you have to see a judge every 10 business days to make the same decision. You've been here 10 days, and that's why we're seeing each other again. All right, so you do have a right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have the right to an attorney. It has been found that you or your family cannot afford an attorney. Mr. Hall has been appointed as your attorney. All right, so, and am I pronouncing your name right? Enya?
Anaya, sir.
Anaya, okay. Okay, Anaya, let's see. You're 15 years old. You're level 1 outstanding right now, which is good. You had no history with the department up until what you're here for now. So, see, back in April, 4th PD had an arrest warrant for you. They responded to a robbery call. They said, girl said she thought she was set up by Anaya, who was a girlfriend of her roommate. And victim said that Anaya was hanging out of the apartment. When the victim came in the bedroom, there were 3 males armed with handguns wearing masks and hoodies in the room. Victim said one of the males put a gun to her head. As they were leaving, a friend of the victim was entering the apartment. The friend tried to run and was chased and shot at by the suspects. Victim 1 and 2 chased after the car and were also shot at by the suspects. The report does not say if anybody was hurt or not. Marshall, mom met with Burslem PD, advised she had information on the robbery. She gave information. So saying one of the people wanted Anaya to set up a motto for a robbery, your boyfriend for robbery, but you said you refused to cooperate. One of the suspects was arrested for a capital murder warrant. During the execution warrant, they seized Carson's cell phone, showed a conversation between Anaya and Carson. During the text, Carson and Anaya developed a plan to rob the boyfriend of drugs and money. So the text showed that you sent a picture of Amato's car and his address. You said you would leave the door unlocked and you were to get half the drugs for your role in the robbery. Also texting the night before, confirming what time Carson would be there. So. Later on, there was text about you and Carson about who called the police. The police were looking for him. All right. Okay, so Anaya, I'm glad you're level 1. Here's the thing. Well, you have to understand. Do you understand what the law of parties is?
No, sir.
No? Okay, so law of parties, that's the law in Texas that says if 2 or more people either plan, commit, or benefit from a crime, that they're all guilty of the same crime. So let's say me and, I don't know, let's say Ms. Turner Hill, your probation officer, she and I planned a bank robbery, okay? And so I'm just the getaway driver. She goes in the bank, she gets the money, she has the gun, and then she gets out of the getaway car and I drive off, okay? And then we go and then we give Mr. Hall, you know, some of the money, and he knows where the money came from, and he goes and buys his wife a new watch, okay? Well, all three of us are guilty of the aggravated robbery because I participated in it as part of the getaway driver. Mr. Hall just benefited by spending the money. He knew about it. All of us are guilty of the same offense. You understand? So even though, from what I'm seeing, you may not have had the gun, you may not have shot the gun, the fact that you're part of the planning and part of the process of this, that's what gives me reason to find that it's probable cause that you participate in the robbery, okay? Now, my policy as a judge is anytime children in Tarrant County are involved with handguns, I take that with the utmost seriousness. Okay? That is, I cannot have that. We are so close to somebody dying. In this case, evidently somebody had a gun held up to their head. I don't think anybody really, I think we all deserve to live life without having guns held up to our heads. Okay? So I hope you understand where I am. You've just barely been here for a couple of weeks. I'm glad you're level 1-0. You've actually been level 1-0. I guess you had a little hiccup and then you just got back today. Okay. I don't know what that's about, but at this point, I'm going to detain you because I need to be very, very comfortable before I release you. Okay. That's how serious the crime is, especially since the other guy involved with this evidently has been arrested for capital murder, which gives me a lot of concern because those are also the people you're hanging out with or affiliating with. Okay. You understand where I'm coming from?
Yes, sir.
Okay. Do you have any questions for me?
I do have one question.
Yes.
Like, will I, if I stay on level 1 and do what I need to do, will I be able to have a chance?
Yes. So there's two things with that. I want to make sure you understand. One, there's two reasons why you want to keep your level 1-0. Okay. One of it is because I review this every 10 days. Okay. And if you drop down, then to me, it closes the door and I'm not going to let you out. Not with this type of offense. Okay. But if you are level 1-0, I take it very seriously and consider it. We do let children out. Sometimes it takes a while. Okay. It's not as immediate as if, let's say, it's a shoplifting case. Okay. But on the more serious cases, sometimes it takes a little longer. But if you show consistent behavior that you're doing what you're supposed to do, that gives me reason to believe I should let you go. Okay. The second reason is you want to give your attorney as much as possible to work with. You will eventually have a trial on this case. And if it turns out that we find that you did do this and you're involved with Carson in this robbery, then comes a question of punishment. Now I have to decide whether to give you probation or to send you to TJJD or there's all kinds of options. And so because of that, you want to keep your behavior level well so your attorney has as much to work with, okay? I know that's very upsetting for you. I don't know if you know this or not, for an aggravated robbery like this, in theory, you can do 40 years in TJJD.
Yes, sir, I understand, and I know what I did was wrong, sir.
Okay. So, I'm going to stop you there because I don't want to go into the facts of what happened or didn't happen. That's for you and your attorney, and we can save that for trial. All we're talking about is the detention, okay? You understand? So I'm not, excuse me for being rude, but I want to cut you off because I don't want you, well, here's the thing. I don't want you to put yourself in the spot, right? I don't want you to say a bunch of stuff that hurts your attorney's ability to represent you or to defend you, okay?
Yes, sir. I just want a chance to be let out on an ankle monitor because I promise you this is my first and last time I will ever be here, sir.
And that is what's going for you. It's your first time. You know, I understand that. I'm looking at these levels, but you understand if there's things with guns, I have to be extra cautious before I release kids back to the community.
I understand.
Even though and I'll tell you what, the fact that you're not the one that actually held the gun, that works out very much in your favor. If you're the one that actually held the gun, it's a very low chance of getting out. Okay?
And Judge, if I may, Mom and grandmother wanted you to know that they're willing to have her home and she would be under surveillance for 24 hours a day, that both of them would be, be there watching over.
Yeah, I haven't shut this door on releasing her or not releasing her. Right now, my concern is because it's so serious, there was guns used, there was guns held to people's head, there were shots fired. And then she was part of the planning. So the people that evidently, according to the report, the people she was involved with, I'm assuming that she knew they were willing to kill other people or shoot guns at other people. And that's the kind of thing that we're all concerned about, okay, as a community. All right, so Naya, so right now the answer is I'm keeping you, but you are on the right path to making you more comfortable, okay? But I do balance everything out. I talk about the bad, but there's also the good stuff I realize. You didn't actually have the gun. You don't have any priors. Your behavior level 1-0. Like these are things it's just, I'm balancing the two things out, okay?
So I do have a chance?
Yes, absolutely. You have a better chance. There are other kids in there that really have no chance. I'm gonna let you know that.
I do not want to go to TJJD.
Well, our goal is to try and do everything possible to prevent kids from going to TJJD.
Yes.
Okay. And I'm going to tell you this. I may not tell you what you want to hear, but I will always be honest with you. I promise I will never lie to you, deceive you. I will be straight up with you. That's my commitment to you. Okay?
Yes, sir. And, am I allowed to talk to my attorney and PO today?
Yeah,
I'll call you in a little while.
Is that okay, Anaya, if he calls you?
Yes, sir.
Okay. All right. Thank you. Keep up the level 1-0, okay?
I love you, Anaya.
Hi, Mama. I love you.
It's going to be okay. Okay.
Okay.
All right. Call me later.
All right. We have Robert Mayfield.
And Judge, on this one, his aunt and uncle are willing to take him. I doubt they're on the Zoom thing today, but they are willing to take him if you're willing to release him.
Where do they live?
In Arlington.
Okay, so they live locally.
Yeah.
Yeah, they live in Keller.
Okay. Keller.
All right. All right, Mr. Mayfield, this is a detention hearing. You've been here for 10 days. The law says you have to see a judge to make a decision to keep you in custody to release you. And so at this point, I want to let you know you have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other court setting. You have the right to an attorney. It has been found that you and your family cannot afford an attorney, so Mr. Hall has been appointed your attorney. All right, so we are here. Now, Mr. Mayfield, I'm very familiar with the case. So this is the manslaughter with a drowning. Is that correct?
Yes.
Okay.
Yes,
all right. All right. So the concern was you had gone to Wyoming, and because your mom took you to Wyoming, and then you ended up with a juvenile court up in Wyoming, which prevented you from coming back down here for your case. Let's see. There's determined sentence approval. Determined hearing is May 4th.
Your Honor, may I say something?
Okay, as long as it's not about the case, I don't mind. If it's about your detention hearing, then you're more than welcome to.
It is. And if you were to release me, say a monitor and stuff, I can promise you I'm not going to do anything. I'm just going to remain in the house like I'm supposed to. And wanted to let you know I have been a level 1 since I've been here.
You're level 1 since April 8th, and then you may have some dips, but right now I believe you. I know you've been behaving while you're here.
Because I don't normally get in trouble.
Right. Mr. Hall, where are we with that psychological? Is it back? You received a copy?
It's back, yeah. Yeah, there wasn't any major concerns on it.
Okay. So he's diagnosed. He's on the autism spectrum. Is that correct?
I'm not sure if they ended up making that finding or not. It was, he was right on the border, I think, where he could get gone in either way.
So where's mom right now?
She's still in Wyoming.
What about dad?
Uninvolved, Your Honor, I believe.
Mr. Hall, what is May 4th? Is it a plea agreement or is it a contested hearing?
I think that's when we were going to get a final date. I'm supposed to talk with Kevin later on this afternoon. He's in a meeting this morning. We're going to talk about the case this afternoon and see if we can, try to get something worked out with it or not.
Is adjudication in dispute or is it just disposition?
Both.
Both, okay. So it's not set for final on May 4th then? That's just another docket setting?
Yes. I think that's when we were going to figure out the final trial date and all that. And I know Kevin's had some problems having witness meetings and stuff with the ME's office because of their involvement with the virus and all that.
Sure. All right, Robert. I'm really glad that you're level 1-0 and you're not having behavior problems back there at all. Here's my issue. Okay, there's something going on right now, and I don't know you, right? I mean, you and I have never sat down and talked before, just chatted. I don't know you as an individual, as a person. Okay, here's my concern. In your case, that there's somebody that's deceased. Okay, and they're saying that there's enough facts or statements to indicate that you're the one that caused somebody else to die. Okay, that gives me such great concern. Okay, I'm not sure what's going on, but what the situation it puts me in is I have a duty to protect the community. Okay, and because of the seriousness of this offense, at this point before adjudication, I'm not comfortable releasing you. Okay? I say this with hesitation because it doesn't seem fair. Right? Because you may not have done this. Like, I understand that and I recognize that, but because we're kind of playing for, I guess the saying is we're playing for pink slips. Okay, like we're playing for all the marbles right now, and it's so serious that I have to take a little extra precaution on this one. Okay? It's not that there was just a threat of somebody dying; somebody actually did die because of this. Okay, because of that, that's not to say that I can predict what's going to happen ultimately in your case. I'm just saying right now, the factors that I have to consider in releasing you, which is things like the danger to yourself, the danger to the community, the likeliness of absconding, the likeliness of reoffending. These are all factors that I have to play into. And at this point, I'm just not comfortable releasing you yet. I do want to let you know, though, I appreciate it's not easy staying level 1 for this long. Like, I get it. Like, I'm not taking that away from you, okay? I want to give you the credit for that, and that it is a lot of work to do that. I'm not asking you to understand, but I'm just giving you the reason why I'm making the decision that I'm making, okay? Just so you don't walk out of the room saying, what the heck happened? I want you to understand why, okay, even if you don't agree with it, all right? Hopefully, we can figure out how to resolve this case soon, though, Mr. Hall. He is now at 127 days in detention. We're getting to the point where, and you may want to tell Mr. Boneberg this, or is the state here, I guess?
I am, Judge.
Okay, Mr. Williams, just to let you know, we're getting to the point now where this case is getting just too old, and we're just going to set it for final disposition. If the state isn't ready, then the state's not ready. But we're going to have to move this probably. I mean, when this coronavirus thing is lifted, we're probably going to have to put this close to the top of the list of resolving. Okay.
I understand.
Okay, I just want to give you all fair notice of this one here, because it's not fair to Mr. Mayfield if he didn't do anything for him to sit here this whole time with me not releasing him. All right.
But we're going to talk more this afternoon on it. So.
Okay. All right. Thank you, Mr. Hall. Thank you, Mr. Mayfield.
Yeah. Okay, that's my last one, Judge. So I'm leaving.
All right, you're excused, Mr. Hall. Thank you.
Okay, thank you.
All right, we have Darian Mullenix.
Mullenix. He's doing Mullenix.
Oh, Mullenix. I'm sorry. Mullenix.
Oh, you know what?
free chat.
All right, Mr. Molnix, I'm Judge Kim. This is a detention hearing. When a child's brought to our detention facility, they have to see a judge within 2 days. And once they're here, they have to see a judge every 10 days to keep on making a decision to keep you in custody, to release you. You have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other court setting. And finally, you have the right to an attorney. It's been found that you and your family cannot afford an attorney, so Ms. Barrows has been appointed as your attorney. All right, so on April 9th of this year, you were adjudicated delinquent for aggravated robbery, and you were given a 10-year determined sentence commitment. So you were, remember, I sentenced you to TJJD for 10 years, but we probated it to a Kenyan state. You're supposed to be placed there on April 28th. All right, so at this point, we're just waiting for a bed to open in Kenyan state. You understand?
Yes, sir.
Okay, and you understand if I let you out now, then the wait period starts over again, right?
Yes, sir.
Okay, so I can't let you go because then you'll lose the spot. Right now, you're supposed to be going on Monday or Tuesday?
Tuesday.
On the 28th, okay? So I can't let you go because if you do, you lose your place in line. You understand?
Yes, sir.
Okay, so I'm going to detain you because I want to make sure you can hold up your end of the deal. But you remember when we had the conversation at your hearing, right?
Yes, sir.
And I told you I just sentenced you to 10 years in TJJD. Remember that?
Yes, sir.
Okay, but I'm giving you a chance that if you do your probation right, you never have to go to TJJD. You remember that part of the conversation?
Yes, sir.
And I also told you that part of getting on probation, though, is to finish the Kenyan state. You got that too, right?
Yes, sir.
So you understand, like, this is all part of that process. Think of this as like walking a marathon, but you're backwards. Okay, you're just walking it backwards. It's not that hard. Just don't lose your focus. If you lose your focus, you're going to fall and you're going to end up in TJJD. Okay, but as long as you pay attention, just one step at a time, you'll have no problem with this at all. Okay.
Yes, sir.
All right. Thank you, Mr. Molnix. And you know what? I won't see you until, man. Honestly, I hope I never see you again, right? Because next week you should be going to Arizona, then you come back, and then you do your probation, and you have no violations, and you and I never see each other again. Is that about right?
Yes, sir.
Okay. All right. Thanks, Mr. Molnix.
That was my only detention hearing.
Thank you, Ms. Barrows.
Wait.
All right, Leonardo Rodriguez, out of custody.
Judge, I'm going to bring him in, okay?
All right, thank you.
Judge Kim, that's the out of custody.
Yes, this is out of custody.
And why don't you sit in this chair right in front of the computer screen? Mom, you can have a seat right here.
Just take them from your room if they want. Or they can come in and do it if they want. Okay, Ms. Rodriguez, are your parents here?
Yes.
Okay. Mom, do you just want to sit next to your son? Both of you will fit in the screen.
Okay. Scoot your chair over just a little bit. Mom, just make sure you put it in the screen as well, okay?
Okay, Leonardo, this is the detention hearing. The reason why he's here is because there's evidently some kind of issue that you're being brought before the judge to make a decision whether to detain you or to release or to let you stay in the community, okay? If I detain you, the law says that you have to see a judge every 10 business days to make that same decision to keep you or to release you. You have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have the right to an attorney. If you or your family cannot afford an attorney, then I will provide one for you. And that determination has been met. Mr. Frank Adler is your attorney, okay? All right, so let's look at this. Back in March of 18, there was a unauthorized use of motor vehicle, which was dismissed because you did deferred prosecution. Then on March 21st, we gave you a drug test and you were positive for marijuana and benzodiazepines, like a Xanax is what it looks like. All right, so on April 21st, your officer gave us a progress report asking for EM because you were leaving your house without permission. Your mom thinks you left the house to use drugs. And so Judge Porter said, you know what, let's just do an out of custody hearing to figure out what's going on. All right, let's go back to April 16th. Judge Terry released you from detention because you were transferred JPS for COVID symptoms, but you were negative. Let's go back to March 21st. People were dispatched for drugs at home. Oh, I remember this one, that dad found drugs on you, pills and weed, and you tested positive for the pills and weed. All right, so this is where we're at. So you had a case, you got out because of COVID, tested negative, we let you go home. Now, evidently there's problems at home, you're speaking out, you're not following the house rules, okay? And there's concern by your parents, and your parents are communicating. Hey, look, when parents call our probation officers, call the court and say, hey, look, there's problems. Those are parents I love. I adore these parents because we're working as a team. Okay, when we're working as a team, Leonardo, what that means is you have no chance. You cannot win a game when your parents and the judge are working together against you. And I say against you because you're fighting it. If you're doing what you're supposed to do, you're working with us and there's no problem, right? So if you want to do your thing, and your thing is opposite of what your mom and your stepdad and I want, then we're going to have a lot of problems. This is going to be very painful, okay? So the fact that your mom is being very communicative and being giving good dialogue with us, that puts me a lot of faith in Mom. And Mom, I appreciate you doing that. Okay, so this is where I'm at now. They're concerned about drug use, about sneaking out. I'm going to let you know that we are going to go to EM, okay, to keep you at home. But the concern right now is whether you continue to use drugs knowing that you have a pending drug case going, right? So I'm going to ask you a question. Don't answer the question yet, okay? Let me tell you the three answers. The question I'm going to ask you that you don't answer is, if I give you a drug test, are you going to be dirty for anything you shouldn't be? Now, before you answer, there are three ways this works out. Number one, you can say, I'm clean. We give you a drug test, you're clean. We'll put an EM on you and you go home right now. No problem. The second option is you tell me that you are dirty, and then we give you a drug test to see what you're dirty for, and then you're dirty. And at that point, I'm going to take you into detention, probably keep you here till you get to level 1-0, and then we'll release you on electronic monitor to go home. Now, the third option is you tell me that you're clean, we give you a drug test, and you end up dirty, then I'm probably going to keep you here, and you got to get level 1-0 and keep it for 7 days before I let you go home on electronic monitor. Okay, so you understand those are the three options. That's the way it works. So now I'm going to ask you, if I give you a drug test today, are you going to be clean or dirty?
Dirty.
Okay, what are you going to be dirty for?
Marijuana.
Marijuana, that's it? Okay, so your probation officer, Ms. Guerrero, then let's go ahead and give him a UA. Just a screen is fine. If he's dirty for just marijuana, then we'll take him to detention. All he has to do is get to level 1-0. We'll release him on electronic monitor, okay? Yes, ma'am.
If I may, I've also, TYRC has reached out to me. And they do have a bed possibly available for him for residential. They would be able to take him next Friday. They have worked with him before, so they feel that his drugs are increasing. He's using more and exploring other things.
So his TYRC is based on the benzodiazepine use?
Yes, and they worked with him in the past.
Okay. Mom, what do you think?
Yeah, I think it's a good idea. That's what I want, inpatient.
Inpatient? Okay.
Yeah.
Leonardo, what do you think?
I agree.
All right. So here's the thing about treatment, right? Is it only works if you're committed to it. Like if you buy into it, if you're saying, this is me. So if you're tired of seeing me, if you're tired of coming back to Kimbo, if you're tired of your mom being all up in your business, all right? If you're tired of think about it right now. What are the 5 biggest stressors in your life? Okay, just in your head, think about it. And of those stressors, how many of those have to do with weed or bars? Right? Yeah. You see what I'm saying? Like if you got rid of weed and bars, I mean, that's the whole point about weed, right? It's supposed to take away the stress in your life. Dude, you're stacking it on yourself, right? If you just cut that out, I mean, shoot, you're almost an adult. You can make bad decisions when you're an adult, but you have to understand when you're a child, your mom has a moral, legal, ethical obligation to stop you from making bad decisions. Yes, I have a legal, ethical, professional obligation to keep you from making bad decisions, okay? Same with Miss Guerrero, same with all these people that are jamming up your life. All of us are doing this because we want to keep a 16-year-old from making bad decisions. Once you turn 18 and you want to go to jail, go to jail. That's your call, right? But when you're 16, your mom can't do that to you, okay? Now when she has spent all this time making you dinner, washing your clothes, making your bed, feeding you, changing your diapers, all these things. And she's invested a lot in you. She doesn't want it to fall apart yet. Just make it to your 18th birthday. And she's like, you know what? I did my job. You do your own thing now, right? So until you're 18, you got to follow the rules. Okay, so let's go ahead, Ms. Guerrero, let's go ahead and tell TYRC and tell Leonardo is interested and would like to go. And I would love to see that happen. You know what? We'll just, I think I'm entitled to do this by law. I'll tell you what, your cases, Mom, your case with stepdad, the marijuana, this is all, you think this is all drug related, right? Yes? Okay. I'll make a deal with you, Leonardo. You go to TYRC and they give you a glowing review on this one. I will, on the court's own motion, defer prosecution on this one, okay? So what I'm saying is, you go to TYRC, you participate, you do everything you're supposed to do, where they're saying Leonardo is good, and we are done with him because he is making good decisions, and we can't help him anymore, then I'll make this case go away. I'll basically dismiss this case. You just go and you don't cause any problems for 6 months, and this disappears, okay?
For 6 months?
After you finish TYRC, if TYRC tells me that Leonardo is good, he's fine, he's done the treatment, he's done the residential, this is my deal with you, because I can do that. In juvenile court, the judge can do this, okay? So I'm telling you, you go through TYRC and get everything done. I will do a deferred prosecution on this one, where we let you go, we don't see you. As long as your mom doesn't call us for 6 months saying Leonardo is causing problems again, then this case gets dismissed. Does that give you incentive to do what you can at TYRC?
Yes, sir.
Okay, buy into it, man. I believe in TYRC. They're good people there. They have good programs there. But if you don't participate, you don't try, the programs are worthless. Okay, you have to be sold into it. Mom, does that sound fair? You sure?
Yes.
Okay. No, hold on. I want you to be sure about this one. You don't sound like you're sure.
Yes.
Okay. All right, Leonardo. So we're going to go ahead and get you at TYRC. Ms. Guerrero will get you the information. Okay? And then I just, yes.
So you are detaining him, so TYRC.
Oh yeah, I'm detaining him for using marijuana while he has a case pending. Yeah, we don't go back on that one. But
thank you.
TYRC is available when?
Friday, the May 1st.
Okay. Yeah, so Leonardo, the way this works is you admitted to marijuana use, so you can get level 1.0 by Monday. So you can get out Monday, and then next week you go back home, spend time with your parents before you go to TYRC. But if you don't get to level 1.0, then you stay here until we release you directly to TYRC, okay? So you're in control of this one, right? Do you see this pattern? Do you see that I'm trying to set up more situations for you to take responsibility for your decisions, right? You're controlling your future. I'm not controlling it, you are. The decisions that you make determine what your future outcomes are going to be, okay? And if you think it's bad now at 16 years old, just wait till you're 30 or 40 or 50, then your decisions they're much more difficult, especially when you have a 16-year-old kid that wants to sneak out of the house, right, Mom? Okay? Anything else? So we'll go ahead and give him, but Ms. Guerrero, this depends on his drug test. If he tests positive for Xanax, then no, he stays in all the way to TYRC. If it's only weed, then yeah, he can get out as soon as he's level 1.0.
Thank you, Judge.
All right, thank you. All right, Micaiah Walden. All right, Ms. Walden, I'm Judge Kim. This is a detention hearing. The purpose of the hearing is to decide whether to keep you or to release you. It's been 10 days since we saw you last. Now you have the right to remain silent, but if you give up that right, anything you say cannot be used against you at any other court hearing, any other type of hearing. You have the right to an attorney. It's been found that you and your family cannot afford an attorney, so Mr. Adniji has been appointed as your attorney. All right, so we are here. All right, so the call about a stolen car. Stepmom called and said that Micaiah took her car. The police showed up. They saw Micaiah being held down by her stepmother. They detained you, spoke to Hedrick, said that Micaiah had taken his white Chevy Suburban from his house and driven it there. Micaiah confirmed the white Suburban was her father's, stated that she drove it there. She is 14 years old and unlicensed. You did not have permission to drive the car, so they brought you over here. So Micaiah, I'm looking at this. You're 14 years old now. Let's go back and so back in November of 19, you had an assault public servant. On November 8th, 2 counts of assault public servant, which you were placed on probation for. So you're currently on probation from January of this year. Then while the assault public servant case is pending, you picked up a criminal trespass case. You had some problems while the case is pending, so we issued a warrant for you in November to bring you in. Then again in January. Then you took probation on January 9th, January 19th. Now we have this theft of property. $2,500 to $30,000. Ms. Smiley, is that a car?
Yes, sir. That was Mom's car.
Mom's car. Okay. So that's January 19th. And then we let you out on April 18th or April 9th. Now you're taking Dad's car. So, all right, we give you a drug test, you're negative. All right, Micaiah. You really, here's the problem. You've set up a pattern for yourself that when we let you out, you're just going to do what you're going to do. And so I, as well as I'm sure your parents and step-parents, are tired of you taking other people's cars and running off and running away and doing what you want to do. So at this point, I'm not going to release you because I'm confident that if I release you, you're just going to do the same thing again. Okay? Now, we have to deal with a probation violation of this one. I think this girl probably needs bigger help. Have we done this order of psychological for her, Ms. Smiley?
Yes, sir. We have got the psychological. It was due back, but I got it back today. But Dr. Menchaca is trying to get clarification on what Dr. Ryan recommended, because it sounds like he's recommending residential.
Yes.
For her.
I think there's a bigger issue here. So let's go ahead and get that. If we need to start a placement search, go ahead and let me know so I can get that started, get an order so we can start that.
Yes, sir.
Okay. My guy, here's the problem. You're on probation. And now you're looking for a felony, and now you're looking at allegedly committing 2 new felonies while you're on probation for a felony. Like, I don't think that this community, what I'm saying is, from what it looks like now, it doesn't appear the community can provide the level of care and supervision for you that you need. So now we have to look at the next level, which is looking at a placement, a long-term placement. These are mostly out of state, maybe Iowa, or Wyoming, or Idaho or something. And it's just 6 to 9 months, and they can really address the core issues that are going on with you. I need to let you know that if you don't engage and participate and try and help yourself, then the last option that we have is commitment to TJJD. Do you know what TJJD is? Is that a yes?
Yes, sir.
Okay. And you understand what an indeterminate sentence is?
Mm-mm.
Okay. Indeterminate sentence is, that's what you're looking at, is I would send you to TJJD, and they would take you in and they would do tests and assessments to figure out what you needed. And they would keep you at TJJD until they felt like you were rehabilitated, that if they release you, you're not going to cause problems anymore. And so we don't have a date. It's not a couple months or a couple years. It's until the point that you make them feel good about releasing you. Now, if you still fight the system and you don't participate and don't engage in the services, then they can keep you all the way until your 19th birthday. Okay? So let you know, one way or another, in your cases, that you're going to find a way to follow the rules and to behave. If you don't do it here, you have to do a TJJD. If you don't do a TJJD, you'll turn 19 there. You understand? It can be a long time. Yes, Ms. Smiley.
If I may, Your Honor, I wanted just to let the court know that Mom is here via phone. She's in.
Okay.
Yes, sir.
Hello, Mom. You know, I didn't ask for your input, but I don't think you would change my mind one way or another. Okay.
She's in agreement with you, Judge Kim.
I'm in agreement.
Okay. Well, good. Glad I didn't disappoint you. All right. So
it didn't ask for mine either.
No, Mr. Arniji, you can't change my mind either on this one. She's, you know, this one's.
I'm just saying.
Miss Walden is she's shown a consistent pattern of behavior it really bothers me when kids are on probation. They're asking for that extra chance or that second chance, and they take advantage of it. Like I shoot straight with you, Miss Walden. I'm expecting you to shoot straight with me. If you're telling me that you just can't do probation, tell me, and we can just send you to TJJD, right? But I need you to be committed one way or another, okay?
Okay.
All right. Thank you very much.
Thank you, Judge.
Thank you, Mr. Aniji. Good to see you again.
I'm out.
All right. So we'll go back to the top of the list, which is Mr. Mooring. We can bring Mr. Brito back in. All right, so Mr. Brito, this is a detention hearing. You've been here for 10 days, so I have to make a decision whether to keep you in custody or to release you. If I keep you in custody, you have to see a judge every 10 days thereafter. Also want to let you know you have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have the right to an attorney. If you or your family cannot afford an attorney, then I will provide one for you. Mr. Mooring has been privately retained, and he is here on this web conference. All right. So, Mr. Mooring, you requested this hearing.
Yes, sir.
Okay. What purpose?
For the purpose of requesting his release to his parents with an EM judge. If we could, he'd be under the supervision of his mother and his father at the house, and they both live at that location. I don't think he's likely to abscond, Judge, and his behavioral history while he's been in detention has been excellent.
I see that he's been level 1-0 since March 24th. Is Diego on his medication in detention?
No, Your Honor, he is currently not on any medication.
Okay. Why not? Mom, are the parents here? Yeah, Mom. Hi,
Mom
Mom.
is here, Your Honor, and she is Spanish speaking, but I'm able to translate.
Okay, so if you can ask Mom, I know he has a prescription. Why don't we have the prescription to give him?
Your Honor, I can actually answer that. Prior to him being detained, he was receiving medication, natural medication through an acupuncturist in Arlington. The reason he was not able to be administered medication was because it was not clearly labeled. It didn't have his name nor the name of the medication, but Mom reports it was for depression and anxiety.
Okay, so how can we get the medication to him?
He would more than likely have to be reevaluated, and the medication would have to state or have his name and the name of the medication. According to Mom, he was last seen by Dr. Lee, the acupuncturist, in February. Okay. So he would probably be due for a medication review.
Okay. If he's got history of mental health that it was to the point where he received a prescription for it, I'm not really comfortable releasing him. Mr. Mooring, how can we get, so Mr. Mooring, I have two options here, right?
Yes, sir.
We can either get Mom to go to the doctor and get the prescription filled again with appropriate bottles or the scripts that provide a copy to us so we understand that they belong to him. Yes, or sir. I can request a psychiatric evaluation, which will happen, I think the psychiatrist comes on Wednesdays. And so at that point, he can wait till Wednesday, and if he needs a prescription then, I want to make sure, because this is so serious, it's going to involve, I'm glad he's level 1-0. He's held it for a month now. I mean, it seems like he's caused no problems whatsoever back there. I don't see anything really indicative that he actually used the gun, kind of participated with it. It would make me a lot more comfortable if he actually had the prescription for him. What do you think we should, if he's about due, if it was February, he's 3 months out, he needs another checkup, another consult. Why don't we just order a psychiatric, get him on his medication, and if it's working, then yeah, and he still stays level 1-0. Yeah, I think I'll let it go. Does that sound fair, Mr. Morgan?
Sounds more than fair, Judge. I appreciate it.
Okay. All right. So, Mr. Brito,
sure.
Certain things working for you. The fact that you've had perfect behavior since you've been back here. All right. There's a couple things that gave me concern about your past, but I'm thinking that you're doing a lot of maturing these days while you're in there. That you're understanding what road, what path your life is headed down. Okay.
I've been reading the Bible and try to get into God and all that.
I'm sorry?
I said I've been reading the Bible and then it made me realize more stuff.
Yeah. Well, what are the 2 greatest commandments?
The 2 greatest commandments?
Commandments, yep.
Love your father and your mother. You gotta respect them. And
No. That's your assignment then. Go find out what the 2 greatest commandments are. All right. And I'm gonna want you to be able to tell me. And that's what I use to guide my life. Okay, so we're gonna go ahead. I'm gonna order a psychiatric evaluation for doctor to see you, get you a current prescription. I need to see you're taking the drugs and make sure they're balanced out before I release you. Okay. I don't know if you were taking the medication when this all allegedly happened. So I'm not gonna release you just because you have a prescription. Right. I'm gonna hold on to a couple days to make sure you're taking it, make sure it's working. You can keep your level 1 behavior there while you're on the medication. That's going to give me the confidence to release you. Okay?
Yes, sir. Appreciate it.
All right. Thank you, Mr. Brito.
Bye, Mom.
And Judge, for clarification, do you want me to still work with his mother to try to get his prescriptions?
No, we won't need that because we'll get an updated prescription after the psychiatric stuff.
Okay, Judge. Thank you.
Thank you, Mr. Morgan.
May I be excused?
You may. It's good to see you again.
Thank you, Judge. And sorry for my computer illiteracy.
No, that's all right. All right. So pursuant to the Texas Family Code, Article 1, Section 13 of the Texas Constitution states that all court proceedings must be in public. However, the Texas Family Code specifically states when a child is under 14, those proceedings are presumed to be closed to the public unless otherwise open. So at this point, the only child remaining on our docket is under 14 years old. So I'm closing this proceeding to the public in compliance with the Texas Family Code.
Outstanding. What happened to my mom? They took her off?
They're taking her off.
So that means she ain't on there?
She'll come back.
Hey.
Hey.
Yes. Hey, Mom.
Hey, chick.
What you doing?
Nothing.